Welcome to our overview of Chapter 6, Due Process of Law. Due process of law is a phrase that resounds through legal history. It is an ancient principle of common sense fairness, forming the necessary foundation of any just legal system. The ideal that all fair legal proceedings require notice of the charges and evidence and an opportunity to be heard is a basic and universal premise of justice. Principles of due process can be traced back to ancient Chinese, Egyptian, and Hebrew laws. Further, the essential elements of due process were no doubt part of an even more ancient prehistory tradition of tribal laws. In the Anglo-American legal tradition, requirements of due process were codified in the Magna Carta, the Great Charter of 1215. The text of the Magna Carta prohibited the use of government powers to punish anyone but by lawful judgment of his peers or by the law of the land. We will sell to no man. We will not deny or defer to any man either justice or right. Similarly, the 1628 English Petition of Rights stated, "No man, of what estate or condition that he be, shall be put out of his lands or tenements, nor taken nor imprisoned, nor disherited, nor put to death without being brought to answer by due process of law." These concepts were incorporated into U.S. law through the Fifth Amendment to the U.S. Constitution, which stated, "No person shall be deprived of life, liberty, or property without due process of law." Similarly, the 14th Amendment declared that no state shall deprive any person of life, liberty, or property without due process of law. In its most basic form, due process requires that government agents must treat individuals fairly in actions that significantly impinge upon their life, liberty, or property rights. They must provide adequate notice, an opportunity to be heard, and fundamental fairness in the process. When government actions may significantly impinge upon protected rights, due process of law guards against two significant dangers: one, abuses of power, and two, erroneous decisions. Concerning due process protections against abuses of power, history demonstrates that absent a firm requirement of due process of law, government officials acting in bad faith can too easily exercise their official powers arbitrarily and abuse government power to punish their personal enemies or dissenters. Concerning due process protections against erroneous decisions, even when government officials are acting in good faith, due process of law helps to guard against erroneous decisions and preventable mistakes by introducing procedural and substantive checks and balances into the process. Procedural due process refers to how the proceedings are conducted, while substantive due process concerns what is done. Procedural due process requires fair and adequate processes, including adequate general notice of the law to all persons in the jurisdiction, specific notice of charges and evidence to individuals accused of breaching the law, and an opportunity to be heard in response to the charges and evidence. Substantive due process requires that government actions must be fundamentally fair, supported by an adequate justification, and must not unjustly intrude on protected liberties. Among practices prohibited by substantive due process requirements are rules beyond the scope of legitimate government regulation, arbitrary or grossly disproportionate sanctions, evident conflicts of interest by adjudicators, and other government actions so inconsistent with basic fairness as to deny fundamental liberties. Government may impinge on a protected liberty interest through capital punishment and liberty through imprisonment. Impingements on life through capital punishment or liberty in the form of imprisonment are limited to criminal proceedings and do not directly involve school officials. The constitutional concept of liberty, however, extends far beyond the scope of liberty under criminal law. As the U.S. Supreme Court recognized in Board of Regents v. Roth, in a constitution for a free people, there can be no doubt that the meaning of liberty must be broad indeed. The Court has recognized that official civil sanctions far short of criminal punishments may significantly impinge on protected liberty interest. Civil sanctions that require due process for protected liberty interest include employment actions that suggest individual moral turpitude, dishonesty, professional incompetence, or otherwise impose a personal stigma on individuals, potentially limiting future opportunities. In Roth, the Court stated, where a person's good name, reputation, honor, or integrity is at stake because of what the government is doing to him, notice and an opportunity to be heard are essential. Similarly, student disciplinary sanctions that impinge on upon protected liberty interests. Protected property interests in public schools include employees' contractual rights and students' rights to a free public education. Educators' property rights to payment consistent with their state contracts are protected by the Due Process Clause. Concerning students, the U.S. Constitution grants no educational rights. But the Constitution's Due Process Clause protects the educational property rights granted to all age-eligible students by their state constitutions. These rights can only be denied through adequate notice and hearing under due process of law. To provide adequate notice, all government rules must be at a minimum publicly enacted, published, and available for review. In a democracy, government officials may not enact or enforce secret rules. Further, to avoid being unconstitutionally vague and therefore void, government rules must be defined clearly enough so that persons of ordinary intelligence can reasonably know what is required or prohibited. School officials may, for example, establish a lawful dress code for students and teachers, and they may enforce that dress code with appropriate sanctions. But everyone subject to the rules must have a fair opportunity to know the rules, and the rules must clearly define what constitutes a violation of the dress code. Rules are constitutionally inadequate if they are not publicly available, or the rules are so vague that they give too much discretion in enforcement to government officials, or give too little notice to citizens concerning what is required or prohibited. Individuals accused of violating government rules must be provided with specific information about the charges against them and any witnesses or other evidence the government plans to use to prove its case, so that the individual has a fair opportunity to prepare a response to the charges and evidence. Government officials must not hide exculpatory evidence or use hidden evidence to ambush the accused. Hearings must be conducted as good faith efforts to get to the truth and fairly enforce the common rules. A determination of how much process is due is based on balancing the magnitude of the potential loss of rights to the individual against the magnitude of the burden on the government in providing due process. In general, the smaller the individual interest at stake, the less due process is required. The larger the interest at stake, the more due process is required. For example, a permanent expulsion of a student or the dismissal of a tenured teacher involves a significant impingement on individual property and liberty interests. Formal and comparatively extensive due process procedures are required in these situations. School officials must provide thorough written notice of the charges and evidence and notify the individual of applicable procedural rights, including the right to obtain copies of relevant documents, to call and confront witnesses, to be represented by legal counsel, etc. In contrast, a short suspension from school may only require an informal notice and hearing. For example, Johnny, your teacher, Mrs. Smith, reported to me that she saw you push Jimmy. The student handbook says that the punishment for violation of this code section is 3 days of suspension from school. What do you have to say for yourself, Johnny? Informal due process proceedings can be quick, simple, and inexpensive. In this example, Johnny's been given notice of the evidence and witnesses against him, informed of the charges and the proposed consequences, and he's been given an opportunity to be heard. Courts also view some disciplinary actions as de minimis in nature. For example, the seizing of inexpensive prohibited items such as candy, balloons, etc., or minor punishments such as an informal reprimand, a brief removal from class, etc. These frequent disciplinary actions are so minor as to require no due process protections under the Due Process Clause. They do not significantly impinge on any protected life, liberty, or property rights, and requiring due process for such trivial matters would unreasonably interfere with daily classroom discipline and waste limited resources. In summary, generally, unless otherwise provided under state law, formal due process is required for a removal from school beyond 10 days. Informal due process is appropriate for removals of 10 days or less, and no due process is required for actions that are de minimis in nature and do not significantly impinge upon any protected life, liberty, or property interest. When in doubt, however, always err towards providing too much due process rather than too little. You can never be faulted by a court of law for providing too much due process, only too little. Further, remember that due process serves valuable school purposes as well. When properly administered, The notice and hearing process can be educational for students, helping them to directly face, think about, and improve their conduct, and helping school officials to guard against errors and unfair punishments that could otherwise cause students and the community to lose faith in the school and to lose respect for school officials. Students, parents, and community members can accept fair punishments, but they are unlikely to accept unfair processes. Due process rights have been solidly established in the Constitution, and they provide valuable checks and balances. In criminal trials, defendants have to stand against the full power of the state, facing serious punishments, including fines, imprisonment, or capital punishment. Disciplinary proceedings in public schools are not criminal proceedings. These are civil hearings where students have been accused of noncompliance with school rules. Nonetheless, the charges against the student may be serious in their lives. These proceedings may impinge upon protected liberty rights by harming the student's public reputation, or take away property rights by removing the student from access to educational opportunities through a suspension or expulsion. These actions could seriously limit the student's future educational employment opportunities. In Goss v. Lopez, the court addressed due process requirements for students in public school disciplinary proceedings, holding that they were entitled to adequate due process of law. In Chapter 6, we will address student expulsions, formal disciplinary notices and hearings, in-school suspensions, corporal punishment, transfers, disciplinary transfers in alternative schools, conducting investigations and disciplinary interviews, questioning faculty and other employees, evidence and chain of custody, conducting hearings, weapons in schools, zero-tolerance policies, gangs in schools, police involvement in schools, off-campus misconduct, and due process in grading policies. We must protect safety and order in schools, but we must also protect the reasonable due process rights of all persons as the necessary foundation of justice and the rule of law. A government under the just rule of law is essential to the protection of life, liberty, and property. But as our founders recognized, in establishing constitutional limits on government, there is no greater danger to your life, liberty, and property than government officials gone rogue and acting above the law. By assuring due process and fair treatment of all persons, even in minor matters, we help to assure that greater abuses and injustices are also prevented. In summary, due process of law requires adequate notice, an opportunity to be heard, and fundamental fairness. Due process is required when government actions may significantly impinge upon protected life, liberty, or property interests. Protected liberty interests in public schools include persons' interest in their good name, reputation, honor, or integrity. Protected property interest in public schools includes students' rights to a free public education and employees' contractual rights. Concerning adequate notice of rules, the vagueness doctrine requires that to avoid being unconstitutionally vague, and therefore void, government rules must be defined clearly enough so that persons of ordinary intelligence can reasonably know what is required or prohibited. How much process is due is based on balancing the magnitude of the potential loss of rights by the individual against the magnitude of the burden on the government in providing due process. More serious punishments and longer disciplinary removals require more extensive due process. Be certain to know and comply with your state's laws defining required due process. In conclusion, to assure compliance with due process of law, make sure that all persons are provided with adequate notice and an opportunity to be heard, and that all rules and proceedings are fundamentally fair. Be certain to comply with all due process mandates under state law. And remember, when in doubt, provide more due process rather than less. Judicial concerns over due process are never triggered by providing too much due process, only too little. Chapter 6 on Due Process of Law addresses issues of vital importance to us all. I hope you will enjoy your studies. Very best wishes to all.